All right, good morning. We are on the record in the 53rd Circuit, and we are providing public access both in the courtroom and also online.
Right away, this case is unfolding in full public view both in court and online. That means transparency is high, but so are the stakes. Everything said here could shape not just the outcome, but public perception too. So here's the question. When the courtroom becomes a stage, does it change how justice plays out?
And we have a short docket this morning. First case is People of the State of Michigan versus Spencer Hope. It's file 26-7142FH. Counsel, you want to state your appearances, please, beginning with people?
Melissa Goodrich, Wayne County Prosecutor.
Daniel Price with the defendant who sits to my right.
Okay, good morning. All right, and we have, this is scheduled for an arraignment and pretrial for a scheduling order, and there's also a bond motion that's been noticed up.
Quick breakdown. An arraignment is where charges are formally presented and the defendant enters a plea. But notice this, there's also a bond motion on the table. That's where things get interesting because bond conditions can seriously impact someone's freedom before guilt is even decided.
So for purposes of the arraignment, Mr. Price, if you had opportunity to review the charging document with your client?
Yes, I had, Judge. We would waive the reading of the charges, and my client elects to stand mute.
Standing mute might sound dramatic, but legally it's pretty strategic. It simply means the defense isn't entering a plea out loud, so the judge automatically enters a not guilty plea. No admissions, no statements, no risks. Smart move. Or just routine. You decide.
Or mute, excuse me.
All right, so we'll enter a plea of not guilty on his behalf to the 2 counts of felonious assault, domestic violence second, child abuse fourth, and reckless driving. Is a forensic center referral requested?
I'm sorry?
Is a forensic center referral requested as to competency or criminal responsibility, sir? Or no?
No, not this time.
What would be the estimated length of trial?
Probably
selection?
3 days.
Okay.
Yeah, I do have one of the victims in the Zoom waiting room that wanted to attend via Zoom,
Oh, okay.
and the victim advocate.
Okay, I do see iPhone, so thank you all. And that person.
Be alleged.
Scheduling here. We could schedule this for, I know different, Mr. Price, I haven't had a case with you. Different counties call them different things. Here we call it a docket call, like a jury status conference or a pretrial that we schedule just to touch bases, whether the case is resolved or whether there's any motions that can be noticed up that same date and time, or whether we need to put it on our trial docket. So we can come back for a docket call on April 28th. I do allow, if you need, appearances by Zoom, video conferencing, or in person is fine. Is morning or afternoon better for you, sir?
Either or, doesn't matter to me.
Okay, why don't we put this then for April 28th? Oops. At 10:50 a.m. And I'll indicate that Zoom appearances would be authorized. And then anything further from the defense in terms of scheduling order, sir?
No, that would be for the purpose of the status, and then we would set trial after that. Is that
Yes, sir. Unless you know for certain, you just want me to put it on our trial docket and get some dates.
No, I just want to make it that it's clear in my mind.
Absolutely.
Thank you.
Okay. Ms. Goodrich, anything further from the people for scheduling?
There, thank you.
Okay, Mr. Price, through predecessor counsel, Mr. Hope had filed a motion to address bond conditions. Did you want to press that motion today, sir?
Yes.
Okay, go ahead.
Thank you. The district court here in this county set a bond on November 3rd, 2025. That conditions of bond prohibits contact between my client and his daughter, who's a minor child. Excuse me. My client is going through a divorce in Emmett County, and on January 28th, there was an amendment or amended PPO order that's connected to this case that allowed my client to have at close contact with the mother of the child solely concerning the child and with the child to exercise parental rights via video chat, no in-person, no phone calls, just through at close. Prior counsel did get a stipulation to that amended PPO by the divorce attorney for Ms. Hope. Prior counsel in this court attempted to obtain the consent of the prosecutor to amend the bond here. She's indicated to me today, and he indicated in his motion, that she could not agree based on the alleged victim statement to her.
And here's where the narrative splits. The defense is hinting at something big claims of fraudulent statements and even suggesting the defendant was set up. That's a bold assertion this early. But remember, in court, claims aren't evidence. At least not yet.
We're only asking that my client be allowed to exercise parenting time with his child. If he could set it up with his child, he would. He wouldn't need to contact the mother of the child. Unfortunately, that can't be done.
Isn't the child one of the
Alleged
one of
victims.
the alleged victims in the case as well?
Correct, Judge. I mean, after getting involved, because I'm now handling the divorce case,
Okay.
there's a couple of motions in that case, excuse me, too many years of smoking. One of which is to set aside a restraining order. The other of which is to defend an alleged violation of that restraining order. After reviewing all the facts and talking to witnesses, I will show in that court that the basis of the restraining order, as well as the motion for show cause, is based on fraudulent statements by the alleged victim in this case. My understanding of this case is my client was basically set up. He at no time admitted to any of the allegations against him. The police on the scene pressed him 2 or 3 times, and he said the same thing each time. I don't think he poses a threat to his daughter.
Okay. Anything else I need to know to understand your position?
I'm sorry.
Anything else I need to know to understand your position?
If you'd like, I can read that amended PPO to specifically state what we're looking for.
No, that's fine. I mean, I think I understand the requested relief.
Okay.
Great, thank you. Ms. Goodrich, people's position?
Your Honor, I would ask the court to deny that motion. That would be unusual in a victim case. This child is a victim in the crime. It's not just a child that they have in common, separate from this crime. She was part of it. The court has the affidavit. This was where they're pursued by Mr. Hope in a vehicle. So there is cause for concern of having any contact at this time. The victim is concerned as the mother for having any contact with her child at this time. I did reach out to the divorce attorney as well to see if there was anything unusual about why they did this in the PPO. There was nothing to, I guess, change my mind as to maintaining, wanting a no contact with both victims in this case.
All right, thank you. Mr. Price, in a rebuttal argument?
This moment is critical. Rebuttal is the defense's last chance to reshape the judge's thinking before a ruling. But notice how the judge is already weighing multiple legal layers: criminal law, family law, and protective orders. It's like overlapping systems. And they don't always agree.
No, only to reinforce the fact that the divorce counsel stipulated to the amended PPO order.
Okay. I mean, and there's different considerations in a divorce case and in a PPO case and in a criminal case. There's a lot of overlap. The Venn diagram would, have a lot of overlap, but there's, some considerations that are different. The requested relief is to amend the bond conditions to allow video contact only. So that would, address any concerns about the physical safety of the child. But in a criminal case, there's some considerations that even go beyond that. I understand Mr. Hope's, presumed innocent, and it's from the statements of counsel. He takes issue with some of the allegations or the context of the facts that are alleged here. and he's got all his rights to pursue those and have a jury determine those things. But he's charged, and there's been a probable cause determination with child abuse and felonious assault with this minor child as the alleged victim of that. It would be quite unusual for a court to allow contact with that victim, even by video, for a child to have witnessed what was alleged. If those are true facts, at this point, there's a probable cause determination of them, would be a difficult circumstance for that child to process. So I would think that there's a risk that even video or telephonic contact with Mr. Hope would present a risk of undue emotional, psychological harm or pressure on the child regarding what her testimony might be.
And there it is, the deciding factor. Not physical danger, but emotional and psychological harm. Courts take this incredibly seriously, especially with minors. So even limited contact like a video call gets denied. It raises a bigger question. Where should the line be drawn between parental rights and child protection?
So I'm going to deny the motion to amend the bond conditions. We'll see you on April 28th at 10:50 a.m., Mr. Hope.
Thank you, Judge. All the other conditions of bond remain the same.
Yes, sir. And I'll just note that on the criminal scheduling order so that there's no proposed order that you need to submit. All right, thank you.
Thank you.
Can we go off the record for a second? Mr. Price, could you approach?
After a brief off-record pause, likely for side discussions or clarifications, we're back. And just like that, the courtroom shifts gears into an entirely new case. Different defendant, different stakes, but the same system at work.
All right, we're back. We can go back on.
Now this is a major pivot. Instead of trial, we're heading straight into a plea and sentencing. That usually means negotiations have already happened behind the scenes. The real question is, what did the defendant gain? And what did they give up?
We're back on the record and resuming our live stream. We have one more criminal matter. It's People of the State of Michigan versus Gloria Jean Dabbs, file 25-7096FH. Counsel, you want to state your appearance, beginning with People?
Melissa Goodrich, Blount County Prosecutor.
No, Nigel, for Miss Dabbs, who appears, I think in person. I can't see her though.
Yes, she is in the courtroom. And so, Mr. Nightingale, do you she did tell us that she spoke with you on Friday. So do you think this is fine to do it in this hybrid way, or do you want us to put her in a jail Zoom room to facilitate any breakout communication, or do you think we're good to go?
I think we're good to go, Judge.
Okay. All right. And this matter had been scheduled for a trial. It was removed off the trial docket based on an anticipated plea. And I think because of the jail cap on that and her credit, counsel wanted to move the hearing up to today for entry of a plea and sentencing. Is that how we're going to proceed today, Mr. Nightingale?
That is correct. Thank you, Judge.
Okay, and I do have the plea agreement and advice of rights. All right. And a letter from Pastor Jones about her participation in jail services. All right. So, Ms. Dabbs, this is going to be, and Ms. Goodrich, do you have an amended information or no?
I do not, Your Honor.
Okay. And that's 1 year and or is it a $200 to $500 fine?
I believe so. I can pull it up here in the meeting.
All right. Well, Ms. Dabbs, under this.
I'm sorry, 200 to 1,000 and 5 days to 1 year in jail.
That's what I'm saying as well.
Okay, thank you. All right, so Ms. Dabbs, by this plea agreement, you'd be pleading guilty to an amended charge of operating while intoxicated, second offense. And that would be a misdemeanor punishable by 5 days to 1 year in jail. and or a $200,000 to $100,000 fine. Do you understand that maximum penalty?
Yes,
Did you read and understand the rights listed on the advice of rights form?
yes,
You understand that that form lists the rights that you give up by entering a plea instead of going to trial?
yes,
And is that what you wish to do?
yes,
The plea agreement provides that in exchange for your plea to the misdemeanor charge, the felony would be dismissed. And there's a sentence agreement that you serve 6 months of incarceration, that it'd be a straight jail sentence and credit for the time that you have been serving. Do you understand the terms of that plea agreement?
yes,
Has anybody promised you anything else?
no,
Has anybody threatened you to make you plead?
no,
Is entering the plea your own free choice?
yes,
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Ms. Goodrich?
No, Your Honor.
All right, knowing all this, Ms. Dabbs, how do you wish to plead the charge of operating while intoxicated, second offense?
guilty,
So back on July 8th of 2025, were you operating a vehicle in Sheboygan County?
no,
Where were you operating
Judge.
a vehicle?
Judge, if the complaint date is actually incorrect. I believe the date was 7/3.
Oh, 7/3, okay.
So I think that's why she says
Okay.
no.
Okay, great.
That's why I said no.
On July 3rd, were you up, and Ms. Goodrich, is that fine?
That is fine.
Okay. On July 3rd of last year, were you operating a motor vehicle in Sheboygan County?
Yes,
Okay. And were you operating that vehicle on a public highway, that being North Straits Highway?
yes,
Before you operated that vehicle, had you consumed alcoholic beverages?
yes,
Did you have some contact with police officers?
yes,
Did they end up giving you a test to determine the amount of alcohol in your body?
yes,
Do you remember the results of that test?
no,
Were they above the legal limit of 0.08?
yes,
Okay, and you don't challenge that test result?
no,
And at that time, did you have a previous conviction for operating while intoxicated? Looks like most recently back in 2007 in Knox County, Tennessee.
I think the actual arrest was 2003, but conviction in 2007.
Okay,
But yes,
okay. And Mr. Nightingale, that of course would be outside the 7-year window for an OWI second, but she's charged with a greater offense of the third within any period of time. So do you consent to the entry of the lesser offense?
I do. Thanks, Judge.
Okay. All right. Are you satisfied with that factual basis, Mr. Nightingale?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
All right. Ms. Dabbs, I find that your misdemeanor plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea, and we can proceed to immediate sentencing then. By my calculation, Mr. Nightingale, I think I've got her at 152 days credit as of today, according to the jail log. Anything you want to say on her behalf?
Yes, Your Honor, please. So I do have her at 153, but I think one day, one way or the other is not going to matter at this point. Asking the court to accept the agreement of the parties here. Ms. Dabbs comes before the court, I believe 70 years of age. She has extremely limited criminal history. Her last conviction was about 20 years ago, and I think as she's informed the court that her recollection is that's actually a prior case that was dismissed and then refiled. And so it looks like it's later in time, but when in fact it was earlier in time. Nonetheless, 20 years, I think, since she's had any history like this, has no prior felonies. This was an incident from July 3rd of last year. There was no crash here. The 911 call does report some erratic driving behavior, but none was actually observed by the officer who pulls her over. Ms. Dabbs was fairly compliant, acted appropriately with the officers. Her blood alcohol content was a 0.113, so not a super drunk, but above the 0.08, as the court's already asked her about. So nothing particularly concerning about the facts of the case itself. I'm sure that the court, is obviously and always concerned with prior OWIs. We hope that since she's had 20 years since that last DUI, since this 6 months of jail is the top of the guidelines for her on an OWI third, that the court will accept this agreement, will consider it appropriate and reasonable under her specific circumstances, not place her on probation. She is on a fixed income. As to her person, Ms. Dabbs obviously received that letter from the pastor at the jail. She's obviously at least attempting to take her time in there seriously and rehabilitate not just herself, but some of the other people, the other folks that are in there. She is a lifelong educator, and I think that's not ever something that's going to leave her and something that she's taken to the jail with her. Trying